Hey, welcome back to another exciting episode of Vondran Legal Hour. Attorney Steve Vondran here with you. Welcome back. We are talking in this podcast, which I'm going to turn into a video for my YouTube channel. I'm trying to hit 1 million views on my videos, and I'm getting there. I'm about 930,000, so appreciate your support. Thanks for listening. We are talking in this video about iStock. We are talking about iStock Getty images. This is the licensing agreement, and I'm going to go over this. I like to call this finePrintLawyer.com. This is something where, as we talk about in contracts law, when you go out and you buy something on the internet, you get this Clickwrap license. Everything says, click here, I agree to the terms, I agree. And so, but nobody ever reads it. Nobody knows what it says. And, the courts, by and large, they say you're bound by that. If you're clicking and finding those kinds of things online, you're bound by that. So, you might as well, I'll tell you what I do, Attorney Steve tip. What I do is before I buy something like this, and not in all cases, but things that are important, like I'm going to be creating this video, with using photos and videos from Getty Images. So I want to make sure I got the rights. I want to make sure that somebody's not going to come back and get me for copyright infringement or trademark infringement or right of publicity violations. So, I'm going to go in and read the terms of the license. And the reason I'm doing this is I'm about to actually go and sign up with their Getty Images account, because I found, doing my research the other night, that they have some great videos. And I'm trying to put together a little video case brief. So that's what I'm going to be doing. But so I thought that it would be neat if I read you the terms of the license so you understand it. Yes, you should still go in and read it yourself. Yes, this is general legal information only and not legal advice. But I'm going to go ahead and try to take the sting out of it for you so that you understand. As we like to say in contracts law, the big print giveth, the small print taketh away. So let's talk about this. I've got a copy of the iStock Content Licensing Agreement printed out. And like I said, it's about 14 pages. It's pretty well written, actually, and it's actually easier to read than I thought it was going to be. But as you know, it's 14 pages, and at least on my printer. And you're going to be bound by these terms. This is essentially a contract. Why is it a contract? Because they have a little box that says, click here and you agree, or by proceeding, you agree. And when you do that, you're agreeing and you're binding the contract. You're making it a valid, enforceable contract. So you're going to be bound by these terms, barring something weird. Maybe there's fraud, or maybe a salesperson lied to you or something. There's sometimes different ways to try to get out of these. Crush my contract, as I call it. But let's go over this. So buckle up, get your popcorn ready, relax in the couch, and hopefully this will make some sense to you. Okay, so these are the terms. These are terms I see here, okay? So let's get going. So basically, here it says, iStock Content Licensing Agreement, last updated June 2017, and this was printed out yesterday, so I would say these are the terms as of 10/17/18. These terms can sometimes change. You also have to read. Some companies get real tricky on you, and they say, "Oh, we can amend these terms from time to time without telling you," and you also agree, which kind of fishy to me. But you can find that as well sometimes. So let's get going. This is a license agreement. So again, this is an agreement. This is not a. You're not getting title to the videos or the photos, the vectors. These things these artists create, they're going to retain title. So what happens is they're licensing their goods, their pictures or photos or digital content to Getty, and Getty's licensing it from them. They're licensing it to you, and everybody's bound by these licensing agreements. Okay, that's how it works in intellectual property law. So you're not actually getting ownership. You don't own it like clear title. You don't own clear title to these works. And a lot of people are surprised when I tell them, it's like when you go to an art fair and you buy a really nice painting from an artist. You bought the painting. You have the rights to display that in your house and tell everybody, look at that, this is my painting, and yeah, I bought this, and it's number 20, and I own it. So it's great, but that doesn't give you the right to go out and mass produce t-shirts or coffee mugs, things like that with the painting on it, because you don't have that copyright. And by doing that, by putting it on your shirts or your mugs, you are violating, or could be violating, the terms of the copyright of the owners. So if you ever want those rights and you're dealing with an artist, like there's a street fair I'm going to in Newport Beach over the weekend, and I typically will buy something, but if you buy it and you really want extended rights and you want to put it into, t-shirts and cups and everything, you better ask the artist and get something in writing. You could do it as simple as putting it on a napkin and saying, this is, you agree to allow me to put these on my t-shirts. So be careful on that. But this is what we're talking about here with iStock. This is a licensing agreement. This is not ownership. You're licensing pursuant to the terms of this agreement, okay? So it says it's a licensing agreement between you and iStock that explains how you can use the photos, illustrations, vectors, and video clips. That's why I'm getting on. I want to get some video clips. They have a really nice selection for what I'm looking for, and I'm trying to put together some video case briefs. So at any rate, says here, by downloading content from iStock, you accept the terms of this agreement. See how it says that? So you're forming a contract by downloading their content. So what type of licenses does iStock offer? Well, they essentially have two different ones. They have a standard license and extended license. Now, everything you buy on there, everything that I'm saying the word buy, but I mean license. Everything that you license through Getty, through iStock, is going to have a standard license. Okay, if you want extended rights, meaning you want rights to put things on a coffee mug, t-shirts, things that you're selling, that you're distributing in interstate commerce, so to speak, you need to get those extended rights. If you don't, you may find that somebody's suing you for a breach of this contract or even copyright infringement, because there is case law authority that says, and it depends on your jurisdictions, but that exceeding the terms of a license, which is what you would be doing, could amount to a copyright infringement, which has very serious damages. I won't go into it. You can see my other videos that are out there if you're really concerned, up to $150,000 per willful infringement. So you don't even want to mess with that, okay? But what does the standard license come with? In a nutshell, I'm going to tell you, it says here the standard license are perpetual. That means if you buy a photo, a photo of something, you've licensed that photo perpetually. So you get it, you license it, you put it into your videos. Maybe you take your photo, you put it into a video, and you put the video on YouTube. Okay, you have licensed that perpetually. You don't have to worry about your membership expiring, and then they say, well, hey, you have to take that photo down. It's in your video. You say, well, it's expired 2 years ago. But it's a perpetual license, so you don't have to worry about that. So that's nice. It's non-exclusive. The standard license is non-exclusive. What does that mean? That means they're licensing the same photo or the same video or the same vector to other clients. So you're not the only one. So don't be surprised if you see the photo out there and you see somebody else has the same photo that they're using. And that's what I mean. You're not going to get the rights to the photo. Say you buy a illustration of a sailboat, and you don't get the copyrights to that. So you could see somebody else doing the same thing. That's the way it goes. In a standard license number 3, you can use it in an unlimited number of projects. Now, I thought that was really good and generous. I was kind of surprised that they would allow you to do that. So I put the photo or the vector in my on my Mac, and I can use it for future projects. So that's pretty cool. You can also modify and edit the content, which is great, because I'll take a photo, I'll download it from Getty Images here on iStock, and I will upload it into my photo editor, and I will make some modifications or edits. So that's pretty cool. No worries. You can make a little, derivative modifications and things like that. So that's pretty cool. And then, of course, the final element of the standard license, what all files come with through Getty, according to this licensing agreement, is the right to perform, publish, and broadcast. Now, for me, that's really important, because like I said, I'm going to do these video case briefs, and I am going to be doing that. So I'm going to be taking a photo or their videos. I'm actually doing both, and those are going into my videos. So I'm going to be broadcasting that on YouTube. That gets broadcast and published and pushed out to the world. So a standard license appears to have the things I'm looking for. So that's good. If you need those extended rights, like I said, you can pay extra to get those extended commercial rights. I'm not going to go into that. That's the basics of that. What else? Now, they have restricted uses. Now, that's also important to know because they're putting certain restrictions on your use. So you just had those. I just told you the basic characteristics of the standard license. There's also restrictions. For example, you cannot use it for an unlawful use. Example, in a pornographic, defamatory, or other unlawful manner. This is reading right from the license here. So no, you cannot use content in a pornographic, defamatory, or other unlawful manner. Now that's pretty broad, pretty wide open. Bottom line, use your senses. Don't do something stupid with their content. They also have, this is under restricted uses, section 3. They also have no commercial use of editorial use only content. So they have some content on their website. I haven't seen it and I haven't really verified it yet, but there's something called editorial use only content. And that's content that they really want you using for news, things of general interest, as they note here, for example, in a blog, textbook, newspaper, or magazine article. It's stuff that's designed for editorial use. Okay, so when you're buying their content, before you click the button and put it into your cart and say, I'm going to buy this, check and see if there's an editorial use only. That's very important because if you start using it in other ways, you can be in violation of this licensing agreement, subjecting and exposing yourself to civil liability. You don't want to do that. Okay, so check before you buy, is the content editorial use only? That can only be used, it says it can use content for any commercial, promotional, advertorial, endorsement, advertising, or merchandising. This type of content is not model or property released, and it is intended to be used only in connection with events that are newsworthy or of general interest. Okay, so that's important. If you're in that area and the clip says editorial use only, make sure you're taking a close look at it and seeing how you want to use it. Now, number 3 on the restricted use, no standalone file use. You may not use content in any way that allows others to download, extract, or redistribute content as a standalone file, meaning just the content file itself separate from the project or end use. So you can't just get their photos and then make it available to other people to redistribute and to do things like that. They want you actually doing something with the photo or video. That's what I take out of that anyway. Number D, this is section 3D, no use in trademark or logo. You may not use content as part of a trademark, design, trade name, business name, service mark, or logo. So they don't want you, and I found that to be kind of interesting actually. So you download, let's say you find a picture of a cheetah or something and you go, wow, that would be awesome for my logo, the cheetah brand. And so, but they're telling you, no, don't try to submit that to the United States Patent and Trademark Office. Don't try to have that be that's not your Nike swoosh. Come up with your own logo, in other words. So don't use it for those purposes. I found that to be interesting. No subscription abuse. You may not stockpile, download, or otherwise store content not used in a project or end use within 30 days after the end of your subscription for future use. I'm not totally sure what that means. I guess they're just saying they don't want you to stockpile a bunch of videos. I don't know. Don't quite understand that. There is something here, this is also in the restriction, section 3F, as in Frank. Sensitive use disclaimer is required. If you use content that features models or property in connection with a subject that would be unflattering or unduly controversial to a reasonable person, for example, sexually transmitted diseases, you must indicate 1, that the content is being used for illustrative purposes only, and 2, any person depicted in the content is a model. For example, you could say stock photo posed by model, No disclaimer is required for editorial use only content that is used in an editorial manner. So what I get out of this is there's going to be some photos that have models in it, men, female, children. They don't want you to take those types of photos or videos or vectors or illustrations and, use those in a way that might be considered unflattering or unduly controversial. That could be a lot of things to that potential model. Okay, and if you do, they need you to put this little description on there. So, see, this is what I mean. The average person, and you're subscribed, I hope you're subscribed by now to our Attorney Steve video channel here. You get these tips that other people don't know. The average person doesn't know that when you download a picture or video on Getty Images, iStockPhoto, if you're using the photo in an unflattering manner or a controversial manner, that you need to have this disclaimer. And if you don't have the disclaimer, you could be in violation of the licensing agreement. Only Attorney Steve subscribers are getting to this level of knowledge. So I hope you're sharing our channel. I hope you're telling other people, as we like to say, quote, be smarter than your friends. Be smarter than your friends. Anyway, that's my little plug for the day. So that's required in restriction section 3G. No false representations of authorship. What does that mean? You may not falsely represent that you are the original creator of a work that is made up of largely of licensed content. For instance, you cannot create a painting based solely on a licensed content and claim you are the author. So that's sort of like false endorsement. There's an element of fraud there. So you buy a big picture of a let's say a race car, and you put it on a big canvas and you sign it with your name and you take it to an art fair and you tell everybody, yeah, I took this photo, blah, blah, blah. So doing that would violate the terms of this licensing agreement. Pretty interesting. No products for resale. This is another restriction in section 3H, as in heavy duty, 3H as in heavy duty. No products for resale unless you purchase an extended license. So again, this is the goods and services where you want to use their stuff on, on-demand products, postcards, coffee mugs, t-shirts, posters, things like that. And maybe you want to sell it on your own website, like a Zazzle.com store or cafepress.com or an Etsy site. They don't want you using these images for products for resale. If you do, you can be violating the terms. This could lead to a what we call account takedown. Next thing you know, you're getting either DMCA notices for copyright infringement for exceeding the scope of the licensing agreement, or you're getting somebody's trying to shut down your account for violating the terms of the website agreement. So you have to be careful on this. Again, if you're going to make these kinds of commercial uses, pay for the extended license. Don't cheap out. Don't think you're going to fly under the radar. Because what we see at our intellectual property law firm is sometimes people will just go. They say, I don't care. I'm just going to do what I want to do. I'm going to get my content out. I'm going to sell stuff. But they don't realize then at the end of the day, we get these letters and somebody's got a cease and desist letter and it's telling you to stop doing what you're doing. And now they want an accounting for profits. They want to know what you've made. They want to know, everything. And now what? You've just wasted your time. And now you may end up giving the money back. You may end up paying infringement fees. You may be sued for breach of contract. So why do all that? Just follow the terms of the agreement that you're agreeing to. It's very simple. Okay. So I'm going to cut through that. What else? Anything else good here? There's a section on limited runs, and I'm not going to go over that. You can look into it, but if you start going commercial, there's limits on commercial, like how many t-shirts you can do, or up to 10,000 posters, or up to 100,000 stickers. So, but if you're doing things like that commercially, these extended things, get in there and take a look at these terms. If you need to, call up the reps at iStock and say, hey, I'm going to be doing this. I just want to make sure. What is also helpful when you're doing these kinds of things is if you don't know, get those emails get those emails from the sales rep. Say, can you send me an email on that? Now, they may not. They may say, I'm too busy. The contract speaks for itself. But some people are helpful and different depending on what company you're dealing with. And get some emails. It's okay to do that. Yes, your idea is permissible. Those things, while it may not always be easy to be admissible in a breach of contract or a copyright case, at least you have the emails. At least you can attach it to a complaint and say, well, look, this is what the guy told me. So anyway, so what else? Moving on here. User accounts, section 6. This talks about, and I don't know if everybody always knows this, but so Getty can monitor your downloads to ensure activity and compliance is in compliance with the terms of this agreement. So if they determine you are in breach of this or any other term in this agreement, it may suspend access to your account and seek further legal remedies. See, I don't make this stuff up, kids. This is the real deal. And they could go and seek further legal remedies for your violations. Number 7, intellectual property rights. Who owns the content? This is kind of what we're getting to. We were talking about this at the beginning. All of the licensed content is owned either by iStock or the artists who supply the content. So they own it. You don't get the rights. You get the rights to use. You get licensing rights, okay? All rights not expressly granted in this agreement are reserved by iStock and the content suppliers. How about that? All right. Moving on. What else do we have here? Anything else? Do I need to include a video credit? So if like for example, I'm going to download about 8 or 10 movies today for a podcast that I'm doing on what I call murder at sea. It's one of the most fascinating cases. You might want to bookmark me and check me. I'm going to be posting it on my YouTube channel here. But I'm going to be buying some videos. And it says, do I need to include a video credit? Yes. If technically feasible, you must include the following credit in visual productions, which is what I'm doing, iStock.com/artist member's name. So at the end of my movie, because I have about 8 or 10 different videos that I'm going to be licensing, I'm going to include a credit section at the end so I can comply with the terms of the agreement. And another thing, it makes you look professional. Yes, it's extra time, it's this, it's more work, but it's to keep you in compliance with the contract, and it's to make you look pro. It's going to look pro, baby, because you're going to have a little credit section at the end. Termination, section 8, termination, cancellation, withdrawal. If they terminate you for whatever reason, you're not paying or you're violating the terms, you must immediately cease using the content, delete or destroy any copies, and if requested, confirm to iStock in writing that you have complied with these requirements. So, but then the next section also goes on to talk about content incorporated into projects or end uses prior to the expiration of the grace period may continue to be used in perpetuity. Remember we talked about that at the beginning? So you can continue. So I'm not going to have to go rip down my YouTube video because it's got the sailboat photo in that I put in 5 years ago. So that's not going to be the case according to my understanding of this section right here. But any content that you may have downloaded into the Getty Images box or online cloud or whatever it is, those have to be deleted. Those are gone. If you didn't use them, you lose them. Use them or lose them. Okay. What else? Getting toward the end here. Keep eating that popcorn. Put some butter on it. Get yourself a cold water. Refunds. I'm not going to talk about that. Content withdrawal. What else? Is this any good? I'm not going to go into that. Okay, let's go into section 9. Representations and warranties. This is stuff lawyers love. This is finePrintLawyer.com, okay? So they're making representations that the content is non-infringing. That's good to know because I don't want to be buying, videos that are, by the way, not cheap. These videos are going to cost me hundreds of dollars. I'm probably going to be putting in a $500 to $900 bill because this is a nice video that I've been wanting to do, and it's a really meaningful video to me, Murder at Sea. So, but they give you a warranty of non-infringement. That means the stuff that they got a video of a sailboat from somebody. Somebody had to warrant to them that it's a good, clean, clear video, and I'm going to get it from iStock. They're warranting to me that it's non-infringing. Good. I don't want anybody coming back at me seeing the sailboat in my Murder at Sea video and going, "Hey, that's my photo." And I say, "Well, I got it on iStock." And they said, "Nope, I don't think so. That's mine." There's going to be a big battle and everything. At least iStockPhoto will indemnify you on this. They will pick up the defense, so to speak, subject to, I'll tell you in a second, limitations, of course. So at any rate, you get a warranty, as it says, except with respect to content identified as editorial use only. Your use of the content in accordance with this agreement and in the form delivered by iStock will not infringe on any copyrights, moral rights, trademark, or other intellectual property right, and will not violate any right of privacy or right of publicity. And all necessary model and or property releases for use of the content in the manner authorized by this agreement have been obtained. See, that's what I'm looking for. So if I'm using a picture with I've got one picture of a guy, he's doing a murder, he's doing a stabbing scene with a knife. That's an actor, that's a model, that's that's somebody's right of publicity, a right of publicity to, in your own image, name, and likeness. So they have cleared all the rights. I don't have to worry about it. I don't have to worry about this model coming back at me saying, "Hey, why are you using my photo, my murder photo?" I say, "Look, I got it on Getty iStock, and if you have a problem, tell them." They have a warranty of non-infringement, so we can deal with that. If I get a problem, I'll tender the defense to Getty and let them figure it out. Again, editorial use only warranty disclaimer. That's the other kind of warranty disclaimer. I don't know if I want to go into this. I'm going to skip that. If you're using editorial use only license, if you're using that, just come in here and read it. There's special sections on dealing with that. It says you are solely responsible for determining whether the release is or are required in connection with your proposed use of the content identified as editorial use only. So if you're using that kind of content, it looks to me like you may have to go and get your own release from the models, from the artists. We can help you get releases. That's what we do as an intellectual property law firm. We can help you get releases, get the rights to do what you're doing, get the clearance, as we're saying. So just remember, if you're using that kind of content and it has models and stuff in it, there could be some additional requirements, okay? No other warranties, that's it. Everything else is provided as is. That's the best we're going to give you, in other words. And let's see what else. You're indemnifying them if you're violating things. This is Section 10, Indemnification, Limitation of Liability. You're actually indemnifying iStock. You agree to defend, indemnify, and hold them harmless and its parent subsidiaries, affiliates, and content suppliers, and each of their respective officers, directors, and employees from all damages, liabilities, and expenses, including reasonable outside legal fees arising out of or in connection with any breach or alleged breach by you or anyone, and blah, blah, blah. Okay, so in other words, you do stupid things, you violate the terms, you're not doing what you're supposed to be doing. They get sued, you get sued, you're going to be indemnifying them. Isn't that fun? That means you're paying the bill. Not fun. But also we have in Section 10B, as in biscuit, indemnification of you by iStock, provided that the content is only used in accordance with this agreement and you are not otherwise in breach of this agreement, and as your sole and exclusive remedy for any breach of the warranties, that means don't try anything else, this is all you're going to get. iStock agrees, subject to the terms, to defend, indemnify, and hold harmless you, your corporate parent, subsidiaries, affiliates, and each of your respective officers, directors, employees, from all damages, liabilities, and expenses, including reasonable outside legal fees, arising out of or in connection with any breach or alleged breach by iStock of its warranty in Section 9, the non-infringement warranty. Okay, so you're going to be indemnified. I'm going to go here down to the little subsection here, subsection BI, as in internet. Unless you purchase an extended license, iStock's total maximum aggregate liability, meaning the total amount iStock is responsible for, whether under this agreement or any other agreement for the same content, is limited to how much? So if somebody sues you, what are they limited to? indemnifying you for? 10,000 US dollars. Okay, well, that's good. I highlighted this because I want to talk about it real quick. Yeah, they'll indemnify you for $10,000, but we do photo infringement cases here as well. And sometimes, either whether you're a plaintiff, you're seeking more than that. You have art at issue, or really nice works of art at issue. Don't be surprised if the parties are claiming $20,000 or more in damages. So the 10,000 may not even totally cover you. So you're taking a little risk with this. If you get the extended license, which you pay more for, the amount is increased to 250,000. That makes me feel a little bit better. I like that amount. But the 10,000 to me, that's kind of needs to be bumped up. But what are you going to do? It's not like you can negotiate these. Well, no, don't let me say that. If you have don't let me say that. If you're a company and you're really doing some heavy duty marketing, advertising, video creation, those kinds of things, you're buying heavy usage of photos and videos, I wouldn't be surprised if you could call Getty and say, you know what, the 10,000, that doesn't cover us. I'm going to be spending a lot of money. I want to get that up to 50,000 per incident is where I'd like to be. But I'll leave that for another day. What else? Limitation of liability. iStockPhoto will not be liable to you or any other person or entity for any punitive, special, indirect, consequential, incidental, or other similar damages, costs, or losses arising out of this agreement. Isn't law fun? We use all these words to cover our bases, to cover everything, so there be as limited number of loopholes as possible. So just giving you a little taste of that. I'm going to go down to section 11. We're just about done here. Hang tight. We're really close. Finish those last few bites of popcorn. Audit certificate of compliance. Most people probably don't know. Attorney Steve fans do know. Upon reasonable notice, you agree to provide iStock sample copies of projects or end uses that contain licensed content, including by providing iStock with free of charge access to any paywalled or otherwise restricted access website or platform where content is reproduced. So that could be YouTube. I have to give them, apparently it looks like, access to my YouTube if they have a problem, they want to audit me. Okay. In addition, upon reasonable notice, iStock may, at its discretion, either through its own employees or through a third-party audit your records directly related to this agreement and your use of licensed content in order to verify compliance with the terms of this agreement. If any audit reveals any underpayment by you to iStock of 5% or more of the amount you should have paid, then in addition to paying iStock the amount of the underpayment, you also agree to reimburse iStock for the cost of conducting the audit. So did you know there was auditing rights? When you buy these photos on iStock, Getty Images, or other, I also use Fotolia, which is Adobe. Did you know there could be auditing rights? No, because you're not reading your contracts. So at any rate, let's move on here. Finally, this is subject to JAMS arbitration. JAMS is probably the biggest. When you have disputes, it's subject to JAMS arbitration. That means they don't want to go to court. They don't want to have a big, expensive court fee. They want to get down and get this thing resolved in an arbitration. Prevailing party shall be entitled to recover its reasonable legal costs relating to that aspect of its claim or defense on which it prevails, and any opposing costs awards shall be offset. So there's arbitration agreement. If you're not happy, something goes wrong. That's pretty typical with big companies these days. Lots of arbitration. And guess what, folks? That's it. I got to the end. We made it. Now this is not exclusive. This is not everything that's in the agreement. This is the big points that I wanted to hit on. Otherwise, we could talk for, probably a full day. But we're not going to do that. We got work to do. So at any rate, this is not legal advice. If you need help with a licensing issue, clearance, breach of contract, copyright, intellectual property, right of publicity issue, this is what we do's, baby. This is what we do's. You can find us on the web at attorneysteve.com. That's attorneysteve.com. If you like this content, feel free to share it and share the link on your social media websites. That's all cool. You have my permission to do that. And more importantly, subscribe. Give me some comments. If you like it, give me the like. If you hated it, I don't know. There should be a little button where you can digitally spit on something and just go, "Puh, puh, that's horrible." But at any rate, So that's it, folks. If you listen to this, you know more than the average bear knows about licensing agreements. And this is going to apply in so many different things that you do and buy on the internet. FinePrintLawyer.com is what I call it. Read what you're doing because you will be bound. For the most part, you will be bound by these agreements. So now that I'm done reading, I'm going over to Getty. I feel comfortable with this for the most part. So I'm going to sign up, and I'm going to be putting together my video, Murder at Sea. So you're not going to want to miss that. It's my favorite case brief from law school, and you're going to get to watch it. All right. Have a great day. Attorney Steve. We'll chat again.